Okay, well, we're here again with another quick lecture on the bankruptcy course. We want to talk about the Ipso Facto clause, which is also called termination of contracts. One of the things you want to understand is that a lot of contracts, and this is very common, have a clause as kind of a boilerplate clause that is included in the contract, and it usually says something like, this agreement shall terminate without notice upon the institution by or against either party of insolvency, receivership, or bankruptcy proceedings. And so basically what it's saying is that upon either party dissolution or ceasing to do business, in other words, the contract, even if you have equity in it, is terminated. And so where this used to come up a lot, where it was problematic, is people would be buying their house on contract from a landlord, and they used to have situations like that where, economics, times go up, times go bad, times go up and down, and so someone loses their job, they're laid off, and they want to file bankruptcy, but they want to keep their house, reaffirm the debt, and keep that going. Well, according to the bankruptcy code, you cannot use these ipso facto clauses. That's just not a possibility. So that's an important thing, and one of the lawyers that I saw when I was reading up on this it says that instead of ipso facto, I'll get it here. It should be not so fast so, according to bankruptcy code. So very critical to keep that in mind, not so fasto. And that is under 11 U.S.C. 541C. So basically what that's saying is that you cannot foresee bankruptcy and cause some contracts to terminate. And the reason for that can be multifold. It can be unfair to a debtor, as we can see, but it is also unfair to other creditors. If someone's put their whole focus on paying off their house and they have it almost paid off and they have all this equity built up in their house, then it would be unfair for the landlord to step in and get that house and not have to repay any of that equity to anybody else. So right in the statute it says, notwithstanding a provision in an executory contract or unexpired lease or in any other applicable law, an executory contract or unexpired lease of the debtor may not be terminated, modified, or any obligation under the contract may not be terminated or modified after the commencement basically of a bankruptcy. So that's a pretty important thing that some people, if they do not have legal advice, may just assume that you will just lose out. Under the old bankruptcy code, which goes clear back to 1898, ipso facto was enforceable. So people were allowed to opt out of bankruptcy. By that I mean creditors could opt out of bankruptcy by just taking the property, and that's that. Fortunately, I think, for everybody, as far as equity is concerned, 1979, all that was changed with a new bankruptcy code, and it's remained that way ever since. So one of the things that's important to keep in mind is that it has to be an actual bankruptcy. It cannot be a threat of bankruptcy, cannot be some other like receivership in state law, something like that. If you file for bankruptcy, then you are protected by the bankruptcy code. Another thing is that when you're drafting contracts, if you're in the contracts class and you have like boilerplate language in your law firm, it would be wise probably to just try to resolve that within your firm, not to use that kind of language, because that can put you in bad stead with the client and with the court in the future. So it just would be wise to just do away with some of that antiquated ipso facto language and try to look at this more modernly, since it's been the law since 1979. So that's just something to keep in mind. I'm seeing that coming up in discussions and wanted to share that with you. Hope you're enjoying these discussions in the virtual lectures, and hope that's adding a little something to your experience in this class. So that's going to be it for today. Always remember, if you have any questions, you can email me at robdawalt@me.com. You can also go through the communication aspect of your class and email me that way. All right, well, thank you. We'll be back later with something else.